Okay, it's 5 past now, and we've got over 660 people, so I'll get started. For those of you that don't know me, my name's Connie. I am a family law barrister at Spire Barristers, and I practice exclusively in public and private law children matters. I roughly do about a 50-50 split between the two, and have had quite a lot of experience now in dealing with private law finding of fact hearings. They can include predominantly domestic abuse issues, so physical, sexual, emotional abuse. I've also dealt with finding of fact hearings which involve abuse of children, whether that be physical, emotional, or sexual. And I've also dealt with non-accidental injuries in private law finding of fact hearings. So I'll just flick on to the next slide, which is going to summarise what we're going to be covering today. The first one is a reminder of the relevant law for private law cases involving allegations of domestic abuse. There will be some simplistic legal principles that I'm going to go through, but what I thought would be helpful was to go through all of the topics that I think we should be discussing with our client in the lead up to finding of fact hearings. And then when this PowerPoint presentation is circulated tomorrow, hopefully all of you will be able to use it as an aid memoir for the topics of discussion with clients. I will then go on to giving you some hopefully helpful practical advice on how we as practitioners can prepare cases to ensure they are trial ready right from the very outset, from the first hearing right through to the listing of the finding of fact. And then finally, what we can do to best support our clients who make allegations of domestic abuse in terms of giving them realistic advice and also supporting them through the process, which, as we all know, can be quite a lengthy process. So the first issue is the burden and standard of proof. We all know, I'm sure, that the burden of proving any allegation lies on the party making that allegation. It should also be explained to clients that the person against whom they are making the allegation does not need to prove anything. They don't have to prove the allegation is false. It is all on the person making the allegation. Again, as you all know, standard of proof is the balance of probabilities. We know from this case, re L&M children from 2013, that findings of fact must be based on evidence, including inferences that can be properly drawn from the evidence and not on suspicion or speculation. The next part is the credibility and memory. And I think this is really important in finding of fact hearings, particularly around domestic abuse allegations, because often we're looking at allegations that have happened within the relationship that may have ended some time ago. For example, if we've had a situation where parents have managed to make arrangements for the children for a period of time, and they have then maybe sought advice about whether or not that is safe for the children, and we're having to go right back to look at what happened within the relationship. So this is the key case for credibility and memory. And it says, it was held in that case, that in everyday life, we are not aware of the extent to which our own and other people's memories are unreliable, and we believe our memories to be more faithful than they are. Two common and related errors are to suppose, firstly, that the stronger and more vivid our feeling or experience of recollection, the more likely the recollection is to be accurate. And we can often see that in cases where we have very hostile relationships between parents. And the second error is that the more confident another person is in their recollection, the more likely their recollection is to be accurate. Memories are fluid and malleable, being constantly rewritten. External information can intrude into a witness's memory, as can his or her own thoughts and beliefs, and both can cause dramatic changes in recollection. Events can come to be recalled as memories, which did not happen at all or which happened to someone else. And the nature of litigation is such that witnesses often have a stake in a particular version of events, We see this all the time. We know that when parents make allegations, they make allegations because they are concerned that their children are unsafe. That's a huge thing for clients. The most important people in their life, they want them to be safe. So we have to remember that they do have a stake in their particular version of events. And it's very important to try and go back with clients to get as clear a memory as possible when making the allegations, when preparing statements, when completing Scott schedules, which I will come on to later, to make sure that their memory is as clear as it possibly can be. Okay. The next important part of the law is seriousness and inherent probabilities. And often misconception is that where an allegation is a serious one, there is a requirement that the evidence must be of a special quality. But it's important to remember that that is not the case. No matter whether the allegation is on the not so serious scale or it's at the very high end of that scale, the evidence and the standard and burden of proof are exactly the same. And it's really important to remember that. The court takes account of any inherent probability or improbability of an event having occurred as part of a natural process of reasoning. So, for example, if there is an allegation that something has happened that is thought to be very, very unlikely, that's something that we need to be discussing with our clients, because the court will naturally take into account whether or not this is likely to have happened. But again, as I said, the fact that an event is a very uncommon one does not lower the standard of probabilities to which it must be proved, nor does the fact that an event is very uncommon raise the standard of proof. So it's just getting that balance between those two principles. So moving on to the binary system. This is something that I often have to advise clients about. Let's say, for example, in a situation where I'm representing a client seeking findings and those findings are not made, it's very hard for that client to let go. And we have to be able to explain that whilst the court proceed on a binary basis, at the bottom of this slide, you will see a failure to find a fact proved on the balance of probabilities does not equate without more to a finding that the allegation is false. So the court is not saying, and this is what we need to explain to the clients, that it didn't happen. It is simply saying there is not enough evidence to prove it. However, after that has happened, the court will proceed on the basis it hasn't happened. And I think that's quite a difficult nuance to try to explain to clients, but it's very important that they know that. I have had cases where not only have allegations not been found, but the court has gone further and said that, for example, the person making the allegation has made them up. The person making the allegation has coerced the child to make the allegation up. So what I would say just as a practical point whilst discussing this is that if your client is on the receiving end of an allegation and your client says that's not true, and not only is it not true, but they are actively lying about that allegation, it's really important for your client's case to be put in that. I would suggest that if your client is facing an allegation in that situation, that you actually plead a finding of the other person is lying, the other person is making this up, so that the court can go that one step further, rather than just having a finding which hasn't been made. Okay, so the main area that I wanted to cover today is domestic abuse, and I cannot emphasize enough how important it is in every single one of these cases to go back to Practice Direction 12J. It's, the holy book of domestic abuse. I read it every time I have a domestic abuse case because there's always something that you may have missed. It's a long document, but it's really, really important. At the very outset of Practice Direction 12J, we have the definitions, which are, of course, important in these types of cases. So it defines domestic abuse as the behaviour of one person towards another person in circumstances where both of those people are over 16 or 16 or over and are personally connected to each other. And that behavior is abusive. Abusive behavior contains lots of different types of behavior. I've set those out on the slide there. Physical or sexual abuse, violent or threatening behavior, controlling or coercive behavior, which is a big topic of conversation at the moment, and since the case of ReHN. Economic abuse, so that could include control of bank accounts, control of bank cards, and then psychological, emotional, and or other abuse. And there is often an interrelation between those various types of abuse. And when we're looking at domestic abuse on its own, it does not matter whether that's a single incident or a course of conduct. However, we will come on to the definitions of controlling and coercive behaviour, where we know that a course of conduct is required. Practice Direction 12J often also sets out what is meant by personally connected to each other, and the examples are set out on the slide there. So individuals that have been married, civil partners of each other, individuals that have agreed to marry one another, whether or not that agreement has been terminated, individuals that are in an intimate personal relationship with each other, and therefore that can that's a wide range of relationships. They each have, or there has been a time when they have each had a parental relationship in relation to the same child, and that means that the person is either a parent of the child, a legal parent, or the person has had parental responsibility. And finally, a situation where they are relatives. So I've had a case previously where, rather than it being previous partners, it's actually been an uncle and a grandma against the parents of a child. So that was one of those situations where it was more that they were relatives rather than being a previous relationship. As I said, we've got the definitions of coercive and controlling behaviour. I won't read those out. I'm sure many of you have read them many times, but I've included them there on the slide, again, for an aid memoir for those of you that want to come back to this presentation after it's finished. It's important to remember when we're looking at allegations of domestic abuse in the context of children law proceedings, so private children law proceedings, that domestic abuse is harmful to children and or puts children at risk of harm, including where they are victims of domestic abuse by witnessing one of their parents being violent or abusive to the other parent, or living in a home in which domestic abuse is perpetrated. And that's the link between allegations of domestic abuse between parents, for example, and the reason why we need to determine these findings of fact in private law children cases. Okay, so this is something that has been a recent topic of conversation since the president of the Family Division has given guidance on really trying to make the most of every hearing. And one of the ways in which to do that is to consider, is a finding of fact hearing necessary in a specific case? So practice direction again comes to our saviour here. It says at paragraphs 5 and 14, I've put those two together. The court should only be holding a finding of fact hearing where the determination of allegations of domestic abuse is likely to be relevant to any decision of the court relating to the welfare of the child, and specifically whether the child or the parent would be at risk of harm in the making of any child arrangements order. So that's another point that really needs to be reiterated to clients. Are the allegations made relevant to the decision of the court in terms of welfare matters for the children? For example, it may be that there has been a one-off incident between parents that happened a very long time ago. It's not a pattern of behaviour. The children were not present in the home, not witness to it. And it may be that that doesn't necessarily need to be determined by the court unless it really is an example of a pattern of behaviour, which of course would put the child at risk of harm in the future. So paragraph 16 of Practice Direction 12J sets out that the court should decide as soon as possible whether it's necessary to conduct a finding of fact hearing in relation to any disputed allegation of domestic abuse. We are often seeing this decision being made far too late in cases, which is causing huge amounts of delay, both for parents and more importantly for the children. It really is incumbent on us to raise at the first hearing that a decision needs to be made about this as soon as possible, so we can get that finding of facts timetabled, all of the relevant evidence, and listed as soon as possible. As I said, I've often had cases which have gone over, not over 26 weeks, referring to care proceedings there, but over a year, at which point a finding of fact hearing still hasn't been listed. So we really need to be looking at that early doors in the proceedings. So Practice Direction 12J sets out the situations within which a finding of fact hearing is necessary. So firstly, in order to provide a factual basis for any welfare report or for assessment, to provide a basis for an accurate assessment of risk. So that may be controlling coercive behaviour, it may be abuse of children, although this webinar is not really focusing on abuse of children, but these are the sorts of things that can result in a later risk assessment. Before it can consider any final welfare-based orders in relation to child arrangements, or before it considers the need for a domestic abuse-related activity. So again, going back to the real reason for finding of fact hearings. I've set out on this slide, and I won't read them out, the matters which the court needs to take into consideration when deciding whether or not there should be a finding of fact hearing. But just to point out, for example, it may be that if a parent or a party has made admissions in respect of some matters of domestic abuse, it may not be necessary to then go on to have a finding of fact hearing on the other allegations which have been made. They also need to consider the amount of evidence that would be required in order to properly proceed with a fair hearing, and or whether these matters could be dealt with as part of a composite final hearing. That does tend to be unusual in private law cases, because it's very difficult for CAFCAS, for the local authority, to complete Section 7, Section 37 reports without that factual basis. So ordinarily in private law proceedings, if there isn't a finding of facts necessary, it does take place as a standalone hearing. As I mentioned, the President gave us guidance. The Road Ahead was published in June 2020. In that, the President of the Family Division said, if the family court is to have any chance of delivering on the needs of children or adults who need protection from abuse, or of their families for a timely determination of applications, there will need to be a very radical reduction in the amount of time that the court affords to each hearing. So parties appearing before the court should expect the issues to be limited only to those which it is necessary to determine to dispose of the case, and for oral evidence or oral submissions to be cut down to that which it is necessary. So these are the things that we really need to be considering right at the very outset of finding of fact hearings. Is it necessary to determine this allegation? Often in private law cases, we have parents that they don't communicate, they simply can't communicate. They've had a terrible relationship, and often they want their day in court. They want to have this argument in front of somebody that is making these important decisions. And again, it's just so important to go back with our clients to saying, is this allegation, and is if proved, unsafe to the children? I think we always need to bring it back to really what is best for the children. We need to be reminding our clients that provided it is safe, a child should be having a relationship with both parents. Just because they can't get on doesn't mean that the child should not have a good relationship with the other parent. Okay. So moving on to the case law, Re-HN and Others is a case from 2021. That is a case that all private children law practitioners need to read. It was held within that case that Practice Direction 12J is and remains fit for purpose for which it was designed, namely to provide the courts with a structure enabling it first to recognise all forms of domestic abuse. So that's going back to the list of abuse that I detailed earlier, and thereafter how to approach those allegations. In Re-HN, the court endorsed the judgment of Mr. Justice Hayden in F&M from 2021 and described that case again as essential reading. There is a paragraph that has been taken from Mr. Justice Hayden's judgment detailed there. Again, I won't read that out at the moment, but that really focuses in on what coercive and controlling behaviour and the fact that there has to be a pattern or a series of acts, and that the court must look at those all together to look at that pattern of behaviour to see whether an allegation of controlling and coercive behaviour is made out. Okay. So the court held that a pattern of coercive and or controlling behaviour can be as abusive or more abusive than any particular factual incident that might be written down and included in a schedule in court proceedings. And that it follows, therefore, that the harm to a child in an abusive household is not limited to cases of actual violence to the child or to the parent. A pattern of abusive behaviour is as relevant to the child as to the adult victim. It's equally important to be clear that not all directive, assertive, stubborn or selfish behaviour will be abuse. In the context of proceedings concerning the welfare of the child, much will turn on the intention of the perpetrator of the alleged abuse and on the harmful impact of the behaviour. So when we are at that initial hearing, we are setting out the allegations that our client has made, whether that be, I'll come on to the various ways that we can do that. But if we're just talking about how that's set out generally, we need to be thinking of asking questions such as what happened? How did that make you feel? When did it happen? How often did it happen? And then we are able to see as practitioners whether there is a pattern here, whether there is a series of acts here, and therefore whether there is controlling and coercive behaviour. So it really is about listening as much as it is about anything else. We need to be asking the right questions of our clients to properly evidence what has happened and to be able to give proper advice on whether or not allegations are made out. Scott schedules. We all know that Re-HN and the court in Re-HN and Others disapproved of Scott schedules. However, in all of the cases that I have had since this judgment, Scott schedules have continued to be used. So in that case, the court said that serious thought needed to be given to develop a way of summarising and organising the matters that are to be tried at a finding of fact hearing, so that the case that the respondent has to meet is clearly spelled out. But the process of organisation and summary does not so distort the focus of the court proceedings that the question of whether there has been a pattern of behaviour or a course of abusive conduct is not before the court when it should be. And we've all seen examples of Scott schedules where you have, for example, the respondent would not let me go and see my friends. That doesn't show really what happened. That doesn't show a pattern of behaviour. It needs to be much more detailed than that. And the use of Scott schedule simply does not allow for that to happen. And I think that is why the court disapproved of the use of Scott schedules, particularly in cases of controlling and coercive behaviour. It's much easier to put allegations of physical violence, allegations of sexual abuse in a Scott schedule than it is to try to describe a pattern of behaviour. So yeah, the court said the process before this court has undoubtedly confirmed the need to move away from using Scott schedules. It will be for others outside the crucible of an individual case or appeal to develop these suggestions into new guidance or rule changes. In practice, that work is likely, in the first instance, to be done through the private law working group, together with the harm panel's implementation group, whose final recommendations may lead to changes to the family procedure rules or in the issuing of fresh guidance through a practice direction. So despite this case being reported in 2021 and the guidance within that case being that we should move away from Scott schedules, we haven't to date had any formal guidance about what we should be doing, which makes things all the more difficult. And I know that we as practitioners have been trying to look at other ways to do that, and I will come on to that in a moment. So the Court of Appeal has not ruled out the use of a schedule as a structure to assist in analysing specific allegations. So again, as I said, they can be useful. Allegations of sexual abuse, allegations of physical abuse come to mind. They are very easily put into a schedule. Okay. Other issues that the court commented on in Re HN and others included what was said at paragraph 58, which is that Practice Direction 12J is focused upon domestic violence and harm in the context of child arrangements and contact orders. It does not establish a freestanding jurisdiction to determine domestic abuse allegations which are not relevant to the determination of the child welfare issues that are before the court. Paragraph 16 of Practice Direction 12J is plain that a finding of fact hearing on the issue of domestic abuse should be established when such a hearing is necessary. Only those allegations which are necessary to the processes should be listed for determination. And in every case where domestic abuse is alleged, both parents should be asked to describe in short terms, either in a written statement or orally at a preliminary hearing, the overall experience of being in a relationship with each other. So again, the court has reiterated in this landmark case the differentiation between parents that simply want to determine every single allegation against each other because of their hostile relationship, and the allegations which we really need to focus on, which are ones which are relevant to the welfare of the children. The last paragraph about both parents should be asked to describe in short terms the overall experience of being in a relationship with each other. I am not usually involved in these cases at preliminary hearing stage. We often come in at pre-trial review, finding of fact hearing stage. So I'm not sure whether or not generally that is being done. If it is not being done, and perhaps to cover our own backs, what I would suggest for the first hearing is that if directions on issue have not given parents the opportunity to file a short statement or any form of document in relation to domestic abuse, then we should really be making use of the position statement provision. A position statement can be filed on behalf of our clients, setting out the types of abuse, examples of that type of abuse, and really giving the court a flavour of that relationship. That will ensure that when the judge comes into court, they know what our client's experience of being in the relationship with the other party is, and it really focuses the mind on whether or not a finding of fact hearing is necessary. I've often seen orders where you have a preliminary hearing, and at that stage, the court orders Scott schedule statements. But I really think we need to be front-ending this. I think we need to be saying right at the outset whether or not we consider a fact find necessary. And then at that point, we can start looking at all of the evidence that would be needed in the event the court said, yes, let's go ahead with the fact find. So ReHN pointed out that where either parent or party assert that a pattern of coercive and or controlling behaviour exists, and where a finding of fact hearing is necessary, that assertion should be the primary issue for determination at the finding of fact hearing. I often find that realistically, when there are a series of allegations, those allegations actually support a finding of controlling and coercive behaviour. It's often an umbrella allegation that can cover various examples of behaviour, various allegations, and that would be how I would choose to plead a case if there is controlling and coercive behaviour involved. I have had a couple of cases where there has been that allegation, and what we have done in those cases is set out controlling and coercive behaviour as the headline allegation, and then included examples. In ReHN and others, they also said that more specific factual allegations should be selected because of their potential probative relevance. That's what I was just saying about some allegations supporting that umbrella allegation, and not otherwise, unless any particular factual allegation is so serious that it justifies determination, irrespective of any alleged pattern of coercive and or controlling behaviour, a likely example being an allegation of rape. Well, an allegation of rape could be supportive, again, of an umbrella allegation of controlling and coercive behaviour, particularly those situations where we have consent that's not willingly given because a party is feeling coerced into giving that consent. But if there isn't generally controlling and coercive behaviour within a relationship, then it's things such as that need to be pleaded. A similar example could be a serious physical assault, and it might well be a one-off, but it's so serious that it needs to be pleaded and considered by the court, because it would simply be so harmful to the children if it were to happen again. Just looking very quickly at some other case law which has come out since ReHN. We have GK and PR from 2021, within which Mr. Justice Peel considered whether or not the first instance judge had minimised several of the mother's allegations. I have had some cases where, for example, let's say there is a clear pattern of controlling and coercive behaviour, but mothers have been asked or fathers have been asked, well, why didn't you report this? And that's something that we really need to get to the bottom of, and we really need to be emphasising how hard it is for people that are involved in these sorts of relationships to be reporting it contemporaneously or later. And we also need to be looking outside of the box at supporting evidence. Now, we'll come on to that shortly about how we can look at various forms of evidence to try and support allegations that have been made, which may not have been reported at the time due to the party feeling coerced and controlled. And also it may not have been necessarily reported to the police or those sorts of services. And finally, the parent may not have ended the relationship simply because something happened. We often see cases where very serious things have happened, but parties remain in that relationship, sometimes as a result of that controlling and coercive behaviour. So in this case, Mr. Justice Peel held that the first instance judge had taken a linear approach to the allegations and did not consider the interaction between the allegations or how they impacted on one another in a holistic way. That comes back to the importance of various allegations supporting a finding of controlling and coercive behaviour or a generally profoundly abusive pattern of behaviour. Mr. Justice Peel also agreed that there was some merit in the submission that the first instance judge had minimised the seriousness of the sexual abuse allegations. The judge had underplayed the significance of words used by the father against the mother, which he considered to be cruel, undermining, and capable of amounting to coercive and controlling behaviour. And I've set out some examples there that the father had used. Mr. Justice Peel did not accept that intentional conduct is a prerequisite for a finding of abusive behaviour. So just because someone doesn't mean to be controlling and coercive doesn't mean that they haven't been. And finally, Mr. Justice Peel noted that in the course of the mother's written evidence, additional allegations were raised over and above those in the Scott schedule, which can often happen in our cases. We can have, for example, a first appointment with a client and they will set out X, Y, and Z happened. And then when it comes to providing that more detailed statement, they say, oh, actually, this happened as well. And I think that's something that we really need to try to get to the bottom of at the outset of these cases, to make sure that that position statement, that their first statement, that the C1A includes as much as they can possibly remember, whilst also trying to balance that with the likely urgent nature of these applications. In that case, the additional allegations that were raised were directly relevant to the allegations in the Scott schedule. Okay, so re JK, which is a case from last year, Mr. Justice Poole offered guidance as to how to approach pleading allegations of controlling and coercive behaviour, and suggested that it should include a summary of the nature of the relationship, a list of the forms of domestic abuse that the evidence is said to establish, a list of key incidents said to be probative of a pattern of coercion and/or control, and a list of any other specific incidents so serious that they justify determination irrespective of any alleged pattern of coercive and/or controlling behaviour. So this is really the closest that we have come to official guidance as to how to plead these cases. What I consider this reflects is in essence a threshold document from care proceedings, where the local authority will set out that the children have been subject or at risk of being subject to physical harm, and set out what has happened to support that allegation. Then they will move on to emotional harm, neglect, sexual harm, and detail examples of behaviour which has supported that. And I think that is something that we could adopt now in private law proceedings, a threshold document type approach to pleading these behaviours. Another important case, and that's from this year, which is A and B in another, and the president of the family division was asked to consider whether he agreed with the judgment given by Mrs. Justice Knowles on whether the family court should apply a consistent definition of rape, sexual assault, and consent, making clear the difference between consent and submission. The president of the family division's findings effectively are set out within that slide, and I'll leave that for you all to have a look at in your own time. But realistically, the overall outcome is that we should not be applying criminal definitions of these sorts of things, because it's too narrow. We need to be looking at the overall behaviour of parents. We need to look at the overall relationship rather than just looking at specific individual events. Okay, that was quite a lot of law, and I do apologise for that. No one really wants to listen to a load of law at 4 o'clock on a Thursday evening. But I wonder if it'd be best just to quickly pause there to see if anyone has any questions at this stage. If not, I will get on to the sort of practical advice, which I have been trying to give as we've been going along. But let me know quickly if there's any questions at this point. Thank you, Alice. The recording and the slides will be shared and circulated tomorrow morning. You will get both of those together. So hopefully that answers that question. Okay. We'll move on to the practical advice then. Let me just close that page. Sorry, just seeing the questions in the chat, so I'll just go on to those quickly. So should a position statement be done for a FUDRA when a C1A is also filed? I personally would say yes. I think the C1A is so limited. It can often get overlooked, I find, particularly when we get to finding a fact stage, and when the court's considering whether or not a finding of fact is necessary. I don't think a C1A is helpful enough in situations where there is allegations of controlling and coercive behaviour, because it just doesn't give the court that flavour of the relationship. So personally, I would say yes. I think also a position statement is helpful to focus people's minds on what evidence would be required if we were to have a finding of fact hearing. And then the next question, how can you use findings made by third parties, such as the police, to support court-based allegations? For example, no further action taken, but a finding of assault. The thing that I find the most helpful with police evidence, and what I would always suggest is asked for, is the charging decision, or the decision statement to take no further action. I have had many cases where I've seen that the charging rationale for not charging, I'm trying to think what, not charging individuals with offences, and often what is set out is the police simply cannot prove this at their burden of proof, standard of proof. So our standard of proof is so much less. And often police evidence is quite helpful in terms of consistencies, and if you're on the other side, inconsistencies, to see what has been said to the police. The crime reports, they're long, they are detailed, there is a lot of stuff to get through to try and get to the very bottom of what's been said. But they are very useful to see. That's how I would use the police. I will come on to, though, other forms of evidence that I think would be helpful for finding of fact hearings. Okay, so the first issue then is to use whether we use schedules or don't use schedules. I personally would use a schedule, or, as I said, a threshold type document to set out the types of abuse. I don't think they give the full picture. There definitely needs to be a narrative statement alongside them. I would use them simply as a form of setting out what the type of abuse is and examples of that behaviour. I think they can be useful. They focus the mind. When you come to preparing finding of fact hearings, you know exactly what evidence you're looking for, you know exactly what you're trying to prove, and respondents know exactly the case that they are facing. As I said, they're particularly helpful in cases where there are specific incidents of abuse, and they can be reduced to a schedule. Controlling and coercive behaviour, they often form a schedule, but I wouldn't be going into detail about the evidence behind that allegation. I would simply have an allegation of controlling and coercive behaviour and perhaps 5 examples of that behaviour. There needs to be a statement for controlling and coercive behaviour to set out particularly how the person felt, because just because someone might not consider behaviour to be coercive and controlling, we can see that by how that person felt. So if, for example, they felt as though they weren't able to leave the house without being checked up upon by their partner might think that that's not controlling and coercive behaviour, but clearly it is, because it can have an impact on the person that they then have to stay inside the house to avoid being checked up on. So the hybrid of the two, I think, is probably the best option, which is, as I said, very similar to a threshold document in care proceedings. What we need to focus on at the very outset of cases is that the court has the full picture and the nature of the behaviour as a whole. As I said earlier, if there is no directions for a Scotch schedule or a statement before the first hearing, use the position statement provision. We always have permission to file a position statement before every hearing in private law proceedings. Okay, so this is really for statements. I tried to put together a structure that can be used in statements that will cover everything. So for each allegation, I would suggest that you set out what happened, when it happened, and where it happened. What was the effect on the child if the child was present, or the child knows about this by being, for example, in the home, having heard it, having been told about it, and also what was the effect on the parent. The family court is not bound by criminal concepts and can make findings of abusive behaviour even when the incident, allegation or behaviour falls short of a criminal definition, but may nevertheless be profoundly abusive and ought not to be ignored. So just because it doesn't fall into a criminal definition doesn't mean that we can't include it. I've given an example there of the difference between violent rape and being pressured into consenting to having sexual intercourse by reason of coercive and controlling behaviour. For example, repeatedly being asked by someone and then the other party then just giving in to stop the other person repeatedly asking. That is profoundly abusive behaviour, and may not fall nicely into a criminal definition, but it needs to be looked at by the court. So then we go on to, was anybody there? We know that in our cases, it's often one word against another. If there are any witnesses or people that have been told about this, perhaps contemporaneously. So if, for example, your client is making an allegation and at the time, let's say it happened, and then they immediately went and told their friend about it, we need to be speaking to their friend to support that. Okay. And then finally, what other evidence might be available? So looking at other evidence, these are the forms of evidence that have come up in my cases. I'm sure there will be more, but it's just trying to get people to look outside of the box to support allegations. They are difficult to prove when there is no contemporaneous evidence or repeated allegations being made to various people. So things that I have thought of and things that I have seen in private law proceedings are diaries. Often people that are in controlling and coercive behaviour, controlling and coercive relationships, they need to get it out somewhere. They need to get out how they're feeling. They often can use diaries, they can use notebooks, they can use notes on their phone to set out how they're feeling. Similarly, they can text people. This doesn't necessarily need to be limited to messages sent between the parties. It can be messages to other people. Did you tell your friends about this when it happened? If you did, great. You know, that's contemporaneous evidence. When filing text messages, social media messages, these always need to be time and date stamped. I have lost count of the amount of times where judges have said to me, this is totally unhelpful. They're not time and date stamped. I don't even know who these messages are between. And so we really need to be cautious of that and making sure that all the evidence that's filed sets out exactly when the messages were sent, who they were sent between, and yeah, as I said, time and date stamped. Police reports, we've spoken about police reports already. Looking into the minutiae of them can be the most helpful. I know it's long, I know it can be boring, but whenever I'm preparing for finding of fact hearings, you can just sometimes find that nugget of information within them. And again, charging decisions, very helpful. Again, lost count of the times where I have had litigants in person saying, well, the police took no further action, so it didn't happen. Well, no, that's obviously not how we deal with it in family proceedings. And if you do have that rationale, you're able to distinguish between the decision that the police took and the decision that the court should make in our cases. Reports to or discussions with the local authority, health, school, or other services, including domestic abuse services. This sometimes goes, it doesn't seem to be considered in finding of fact hearings, but often parents, if something has happened to them, they talk to somebody about it, as I've said, whether if that's not a friend, they'll likely talk to professionals. Have they told their GP about it? Have they told the teachers at school when just in conversation when they've gone to collect the kids, drop the kids off? Have they spoken to DVAT workers about this? All of this is evidence that we need to build in order to prove these allegations. Often those who have been victims of domestic abuse have had counselling, they've had therapy, they've had appointments with psychologists, psychiatrists. Whilst those documents are confidential, your client is able to go to those people, ask them for the notes, and file and serve whichever notes are relevant if they wish to forego that confidentiality of the of those appointments. And another one is photographs. Again, these need to be time and date stamped. For example, I have recently had a case where an allegation was made that something happened. My client was not even at the place where it was alleged to have happened, and therefore we were able to file photographs showing where they were. We had the time and date stamp, and we also had the location, which is now shown on all iPhone photographs. So that can be really helpful, particularly when defending allegations, even though I know it's not on them to prove it, but it always to prove that it didn't happen, but it's always helpful to consider. And as I've said throughout this webinar, we need to be asking for permission to file this evidence at the earliest opportunity. We don't want to get to a pre-trial review and end up having loads of this stuff come out. We don't want to be in a finding of fact hearing where clients are giving evidence and they say, well, I sent my friend a message about it. We need to have that right at the outset. This is another consideration. Is there evidence of vulnerability within or overdependence within a relationship? A vulnerable person may not act in the same way as someone who is more independent or confident if they were exploited or abused in a relationship. So this goes back to individuals who haven't felt able to report things. And I think this is quite a helpful legal principle to be aware of when trying to prove allegations. It's something to raise with the court. It's something to raise with the judge when they say, well, there's no supporting evidence of this allegation. Okay. So case management, we need to be thinking about third-party disclosure orders. Is it necessary and proportionate? In what respect is it said that the proposed evidence supports or undermines an allegation? Again, as I mentioned, for example, maybe somebody said to their domestic abuse worker that this had happened. It's better to have specific disclosure orders rather than catch-all disclosure orders. So, for example, if they say this happened between these dates, ask for police disclosure between those dates, it means that things don't get lost in the evidence. And then finally, would a summary suffice? So let's say there's been mental health difficulties. Usually a summary from the GP is enough rather than their full GP records, which often clients don't want disclosing in any event because naturally they are private. So, okay, witnesses. Sometimes in my career, I've had cases where witnesses are called to give evidence, but they're not helpful. For example, they say things like, trying to think of a good example, that person wouldn't have done this. It's just not helpful at all. What we need to consider really when looking at witnesses, does their evidence go to the issue to be determined? Have they seen the abuse? Have they indirectly witnessed it? Have they been told by it? They're the three main areas of witness evidence that I find to be the most important. Primary evidence, of course, is of utmost importance, but hearsay evidence we know can still be considered. So that's the examples of they've been told this has happened. It may be that often they are not challenged. And for example, if someone says, X told me this happened, the other party won't want to cross-examine them because that person may well have lied to them. But again, it supports the case. Participation directions and a ground rules hearing. These are usually dealt with. The court's quite good at dealing with them, but usually they need to be brought up by us. But Section 63 of the Domestic Abuse Act establishes a presumption that where a party or witness is or is at risk of being a victim of domestic abuse from a party to the proceedings, the quality of their evidence or participation as a party is likely to be diminished. So that's quite a helpful provision for clients who have alleged domestic abuse. By way of that provision, they are presumed to need special measures. It's the obligation to consider vulnerability is the court's, regardless of whether a party is represented or if participation directions are sought. I would still recommend that we seek them where we can, although there has been case law recently where the courts have been criticised, first instance judges have been criticised for not considering those provisions. Okay, so finally moving on to how to support clients. First and foremost, we need to explain as simply as possible the essential law. I've set out effectively the issues of law that we have covered in this webinar today, and that's what I meant at the beginning when I said hopefully this will be an aid memoir for things to discuss with clients really at the outset of cases, rather than them coming to a finding of fact hearing thinking this is going to be really easy, there's not much that I have to do. They need to know right at the very outset the strengths and weaknesses of their case. And also the purpose of fact-finding hearings, the relevance to the making of a child arrangement order, assessment of risk and proportionality, and again, that the court does not need to determine every allegation that may be raised. Expectation management, absolutely key. Clients need to know the strengths and weaknesses to their case, and those strengths can include, for example, consistencies in their evidence, making sure that whoever they have made this allegation to, the story is always the same. Any contemporaneous evidence in support, thinking outside the box about where we may get that contemporaneous evidence from, and any supporting witness evidence. Weaknesses, whilst not necessarily something I agree with, he said, she said allegations where there's no independent evidence, they are desperately difficult to prove, particularly when that comes with inconsistencies in their evidence. And finally, I think we just need to focus on what is best for the children. Going back to what I said earlier, just because the parents don't like each other doesn't mean that the children should not enjoy a relationship with both of them. All right, so that brings us to an end of the presentation today. Thank you all so much for listening and for taking the time to join me. I'd really like to open this up now to a bit of a question and answer part of the webinar, or if there's anything that anyone wishes to discuss, I think that would be really helpful. If you don't want to ask any questions now, please feel free to email me separately or to email my chambers and I will answer them for you. And like I said, the slides and the recording will be sent round tomorrow morning. But please let me know if you've got any questions now, either in the chat or the question and answer, and I will do my best to answer them. I won't be offended if everyone wants to go home. I can understand at this time why you might want to, especially given now it's dark outside. Okay, haven't seen any questions yet. Don't blame any of you. Like I said, if you do want to send me an email directly, I'll pop my email address in the chat now so that you can do so. And hopefully I will see all of you soon.